Lordship, I'd like to mention item
Yes, Mr. Thaba.
27, Your Lordship.
Mentioning for upgrading.
Your Lordship, we were supposed to file rejoinder, but the MD is
Sir,
out of
Thaba.
station.
It's good to see you in court sometimes, so you must do the hearing today, since we grace your presence.
Your Lordship, rejoinder has to be filed, Your Lordship.
My lord, rejoined to the affidavit of the state, my lord. Gomorrah, my lord.
Is it a point of law or is it a point of fact that you have to file rejoinder?
Lordship, there are certain points of facts as well as law, Your Lordship.
Yes. How long?
2 weeks, Your Lordship.
Okay, 2 weeks to enable Mr. D. Thapa, alert counsel for the petitioner, submits that due to inadvertence the rejoinder could not be filed. Stop. He prays phones allowed further 2 weeks to file the same. This amount of 2 weeks, yes.
Highly obliged.
Your Lordship, I beg to mention item 29.
Yes,
Item 29, Your Lordship.
29.
I'm appearing on behalf of respondent for Your Lordship.
You for a petitioner? Who is the petitioner?
Which number?
29.
Oh, may I please, Your Lordship? They
Yeah,
are
objection.
always taking time, my lord. Anyway, 1 week time may be given.
1 week time, the request of yes. Yes, who was that talking from the corner? Can't see anybody. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 3 from supplementary list, Your Lordship.
Why? Was that well today also?
Your Lordship, he's not well, Your Lordship. He's come down with fever also, Your Lordship, that's why.
Oh.
We've already mentioned, informed the other side, Your Lordship.
When?
Your Lordship, 2 weeks' time?
2 weeks. Okay, 2 weeks, yes.
Much
Yes.
obliged, Your Lordship.
Who is this person?
Please, Your Lordship, with the consent of the other side, I beg to mention item number 32.
32. Yes, 32, 32. Who's the other side? 32?
I'm praying for adjournment.
Here on behalf of Mr. Pathak.
Yes, Lordship.
No objection, Your Lordship.
This is 22. This is the matter for 3 weeks. At the request of the counsel petitioner. Yes.
Lordship, I have a request for upgrading,
Yeah?
upgrading to analogous matter, item 33 and 35.
What is this?
If your
upgrading?
Lordship permits, because there is some urgency in the matter.
Who is the other side? Where's the other side?
I'm here, Your Lordship.
You ready? Look, otherwise you can have it when upgrading to when? Today?
Today we are. If
Otherwise
possible,
you can do tomorrow.
That was
You become prepared because you can't just take them by surprise.
all ideas.
32 and
35.
32 or 35, Your
the
Lordship.
similar matters or the
Similar, Your Lordship. Yes,
Similar, analogous
32.
matter.
No,
Analogous,
33 and 35, Your
35.
Lordship.
What's the matter about?
This is your lordship that there are around 60 number of writ petitioners. They were appointed by due process of selection as per the rules. And they were also appointed on the vacant sanction post, but advertisement was made on a contract basis. And I have got two issues. One is for regularization, other one for equal pay for equal work. These are the two issues which are involved, and facts are mostly not disputed. It's only
33 and 35. So what's the
33 and
urgency? What's the
35.
urgency then? What's the
urgency is this, your lordship, because from the last 10 years, these
No, one urgency means whether they are under threat of being terminated or
No. There is no
Then-
such, Your Lordship.
Your lordship, there are two factors. One is that from the last 10 years, your lordship, they are getting a salary which is at the starvation point. Now, to keep a person employed on a wages which even cannot give them 2 times bread is absolutely unconstitutional, your lordship. And secondly, that they have advertised the post,
yes.
and this court has passed the state
When was it advertised?
advertised in the month of February of this year, 9/2. Now this court has passed the order of status quo. In that view of the matter, your lordship,
Okay,
even
no, if he has no objection tomorrow, we'll take it
yes,
tomorrow.
your lordship,
Yes,
as
then,
a fixed item, your lordship,
we'll put a supplementary hearing this.
yes, supplementary list. All right. Highly
Mr. Vicky Jindal, General Counsel senior counsel submits that, prays that the item number 33 and 35, which are similar, be upgraded for hearing in view of the urgency involved. Stop. Mr. Andy Shulai has no objection.
Lordship.
This is the matter tomorrow as a fixed matter and supplementary list for hearing.
Highly object.
Oblige, Your Lordship.
Yes.
Your Lordship, can I pray for this matter item number 17?
17.
Is a connected matter to 22?
17. No.
The
No. He's prepared. He's ready. He can make out.
I think senior counsel is on sanction leave, I think, yes, sir. So,
Who's on sanction? He's there.
no, SP Manta, senior counsel.
Oh. Mr. Kushi, ready on the matter today, no?
I've seen these things when he's on sanction leave.
How long? Just 1 week.
he's in, like, he can be hospitalized. Or
He's in hospital? Oh, okay. As a senior, learned senior counsel for the respondents set to be hospitalized, let these matters appear 2 weeks hence. 3 weeks hence. Okay. That is item number
17 to 22.
17 to 22. Yes. Well, what's happened to him?
No, his leg got injured, so that's.
Oh, he's in Guwahati or in Shillong?
No, right now he just came back, so but he has to go back.
Okay. You should see that on he's indisposed, he's not well, yes.
May please, Lordship, I beg to mention 31, item number 31.
31.
After week, Your Lordship. And for responding to court.
Why?
Lordship, I need some time.
What's the matter about? You're not for the petitioner?
I am for the respondent, Your Lordship.
What's the school matter?
Private respondent number 4, yes, Lordship.
Okay, after 2 weeks, at the request of what is
Respondent
the number?
number
MS
Preparing for the petitioner.
Chisa 4104. Note down and Raji for petitioner. Yes.
May it please, Lordship. Lordship, I beg to mention item number 30, Lordship.
30?
30, Lordship. This is a school matter, Lordship, pertaining to the managing committee.
Lordship, last question also this same way, I think the time.
Lordship, actually, the Miss P. Biswakarma was the conducting counsel in this matter.
The conducting counsel?
However, she her father is in due to the ill condition of her father, she is not able to come to court.
She's arguing the matter?
Yes, sir. She was supposed to
Okay.
argue the matter, Lordship.
1 week. 1 week. At the request of the council petitioner.
Next Monday.
Mr. Devnath, 1 week, you always ask for time, they never say anything. Have some give and take also.
May I please, Your Lordship, I'm
Yes.
preparing for responding 5, 6 and 8.
5, 6 and 8. Okay. Yes. G. Sharma. Yes.
Obliged, Lordship.
I'd like to mention item number 28. For 1 week time, Lordship.
Only, yes.
Supplementary list, item number 1.
Oh, it doesn't matter. Yes. You have received copies?
Lordship,
What do you have to say?
Lordship has expressed a concern that a practice which has been going on for a long period of time, whether that can be injuncted after about 14-15 years. So before I answer that question, may I just take your Lordships through the facts? Apparently,
You don't look at the facts. Look at the okay. Just look at the permission that's been given.
Lordships.
Just read. Look at the permission.
Lordships. Firstly,
What does it say in bold? What does it say in bold letters? Just come to the permission, Mr. Sen. See, without interfering without deciding competing rights. Where's the permission? Yes. Page 22. Correct.
22.
See clause 2.
I've seen that.
Then
what I'm trying to say,
why should deprive the public of a mela?
Perpetuity, number 1. They were not in perpetuity. He's been taking these permissions from 2004 on the premise that this is a walk property. All of them. Now, I'm instructed that even since 2004, we have been taking steps like writing letters to the DC not to grant these permissions. Nowhere has been any kind of adjudication on the competing rights of the parties. I understand what they've said in para 2 that they will not assert a right, but Lordship will kindly appreciate from 97 onwards, on the basis of an order which has been set aside and upheld by the Honorable Supreme Court, on the basis of an observation which does not exist as on today, he's been claiming that this is a WAF property and continuing to hold these mailers. What we're simply saying is that the DC should have taken into consideration the present status of the case.
Then why did you file that the DC was never heard also?
So I'm instructed to inform this court that we have taken steps. If Lordships permit, we can file an additional affidavit to bring that on record. Now kindly see, my lords, there has been a concealment of facts. Clear concealment of facts. They still hold, my lords, in their own statements in the revision application, they do not say at any point that those observations of the Honorable Trial Court have been set aside by the High Court and upheld by the Honorable Supreme Court. Nowhere has that been mentioned. They still believe that this is a WAF property. And he has been appointed by the WAF Board.
Leaving all that aside, Mr. Sen, what I'm saying is if it's a mela has been held every year, if the permission given is clearly states that permission should not be used by organization to present their claims of disputed property in any court of law. Like you have been precluded by the permission itself.
I understand.
Like the thing is that the mela can go on. What's the big hassle?
Difficulty with
Then, why did? See, if you have any other, like collateral issues with regard to who is to rightful, like who's to maintain the shrine thing, that's fine. But the holding of a mela should not, be, what do you call it, somewhat intertwined with the claim over possession or claim over ownership or whether it's WAF property or whether it's not. That's all.
Our only concern, my lords, is I understand the concern from Lordships.
The people enjoy the mela, correct?
I have no difficulty with that. We're not trying to stop that. What we are saying is that this gives the picture that from 97, on the claim that this is a WAF property, they've been asserting their right. Nowhere has a DC even indicated.
Their grievance is that order was given by the Deputy Commissioner allowing you to have this, allowing them to have the mela, fine. But without, without the parties being heard anything, the trial courts injuncted.
No, they were heard.
Till the, without the who was issued the, on what basis the permission was issued. What materials were put before the Deputy Commission. That's not before the court. Correct?
No, my lords, apparently they have said that they filed an objection. In their application, they've said that they have filed an objection, but the learned trial court.
So what propose? How do you get out of this mess? Because we're not going to go into seeing who has title, who runs the shrine, whether it's WAF property. That's not a concern of the court in this proceeding. That's all. So only thing is that permission has been given and it's been stopped by the court without, the order also, it's not very happy.
I think the order under 115 court has exercised discretionary powers. Court has taken note of the fact that the original premise on the basis of which they obtained these permissions, that observation does not exist as of today. The Honorable High Court has made it very clear it is not a WAF property. And on the basis of that, mechanically these permissions have been granted over the last couple of years. Now, may I just present an alternative for Lordships to consider that we be allowed to at least place our case before the DC before any further permissions are granted. My lords, kindly see from 97 the suit is lingering. I am the plaintiff. Lordships will recall last year, about 2019, we had come back before this Honorable Court in relation to another set of proceedings. Some third party claiming to have some sort of a title filed a belated application for impleadment in the case, which was allowed. We had to come back before Lordships. In fact, my learned senior as petitioner was before Lordships. That was also decided in 2009.
What happened?
This is being delayed over years and years and years. From 97, this
what happened when it came before the court?
I have the copy of the order.
By this bench?
Well, which is why Lordships would be able to recall the name. It had appeared in the causes earlier.
Those strangers were not allowed to be impleaded as a party. They were not impleaded as a. That is out of the picture, out of the context.
What I'm saying is that since 97, the suit is pending, lingering on some count or the other. Now, the next date fixed for final hearing of this case is on the 1st of June.
What is the finding?
The finding is that page 6, the last page, para 11.
Now what happened to impleadment?
So impleadment was allowed subject to the law of limitation which lordships have observed. Yeah. After that, they did not appear any further.
The one who
they don't appear in the matter.
They were interlopers.
They don't appear in this matter. So we don't know who these people are. They're just purposely and deliberately delaying the final disposal of the suit. Now, in the meantime, what has happened? From 97 to 23, the respondents are enjoying this property on the basis of a false observation. An observation which does not exist as on today. That it is a WAF property. And that he has been appointed by the WAF board. So, my rights need to be protected. If the suit is going to be pending for 20-30 years, and the respondent enjoys the suit property and enjoys possession, what is the point of the suit, Manoj? So, what I would pray.
Let's go to para 6
of
the revision application. He says he's the Khadim.
Yes, Lordships. Kindly see. On the basis of what? Kindly come to page 3, para 2.
Okay.
May I read, Manoj?
Yes.
That the Dargah of the Shah Kamal Aulia, also known as Peer Baklai Estate, situated Mahendraganj, Southwest Garo Hills, is a WAF property. That is WAF Alaha, public WAF within the meaning of Section 3 of the WAF Act. And is registered as such with the Meghalaya WAF, Board WAF in its register maintained under Section 37 of the WAF Act, which was under the care of the Khadim caretaker Sri Luftur Rahman Khandakar, who had lost his eyesight in the last part of his life, and subsequently the WAF board had appointed the petitioner as Khadim of the Dargah by order dated 8/4/97. That being agreed by the petitioner's appointment as Khadim of the said WAF board, the former Khadim filed a suit in the court of the Assistant Deputy Commissioner West Garo Hills Tura, being title suit number so and so, against the petitioner for a declaration that the said Dargah was his personal property, without implementing the WAF board as a party to the suit. That the petitioner, on receipt of the summon from the court as a defendant, filed an application before the Learned Trial Court under Order 7 Rule 11 for rejection of the plaint on the ground that as the suit property is a WAF, the Learned Trial Court has no jurisdiction to try the suit. That during the pendency of the said suit, the plaintiff Luftar Rahman died on 25/6/98, and thereafter his widow, that is a respondent, got herself substituted as the plaintiff in the year 98, and thereafter the suit proceeded and travelled up to the High Court several times and once at the Supreme Court, but even after a quarter of a century, the suit is yet to reach its logical conclusion. That being the Khadim caretaker of the suit property, the petitioner continued to serve the shrine under the overall supervision of the WAF board. Now, this is absolutely incorrect, my lords. Kindly see what has happened from the passing of the order in the 7/11 proceedings. Still, the Supreme Court has not been indicated. This is a clear case of concealment of fact. What actually happened, the Honorable High Court set aside that order rejecting the suit, as well as those observations that this was a WAF property and that he was appointed by the WAF board. All those were set aside. Now, none of that has been revealed here in this petition. It is a case of concealment of fact. Those were absolutely relevant for Lordship's consideration.
Then where is that? How do you appreciate that then?
Well, which is why I would allow me to file an affidavit to bring that on record. It was a duty, bounden duty of the petitioner to bring this on record. Lordships will have to pose this question to them. Why have they concealed this? This was relevant.
Yeah, 1 second. One second, Mr. Siddiqui. Yes, sir. Don't get excited.
Para 6 then.
Yes, para 6, yes.
That being the Khadim caretaker
of the permission, yes.
Lordship, that being Khadim caretaker of the suit property, the petitioner continued to serve the shrine under the overall supervision of the WAF board.
Is that correct? Under supervision of the WAF board, is that correct? No.
On the basis of that order. So we don't have that application.
Yes, my lord, it is correct.
Okay, then
we are not privy to any of this.
Yes.
So I may just point out, on the basis of the order of the trial court, which observed that this was a WAF property and he had been appointed as a caretaker by the WAF board, and the suit was dismissed, he applied for this permission only in 2004, not prior to that. So from 97 to 24, he had never applied for holding the Mela. It was only in 2004 on the strength of the order of the Learned Trial Court, not on the basis of anything else.
Okay.
And as per its convention, used to conduct a fair Mela every year with effect from April 2004 to 22, that is for a continuous period of 15 years, with due permission from the DC West Garo Hills Tura, and after the bifurcation of the district with the permission of the Deputy Commissioner South Garo Hills Ampati as per the permissions orders listed below. Kindly see 2004-2005. This is not a permission in perpetuity. Every single year he goes back, claiming to be appointed by the WAF board and on the strength of the order of the trial court. There is no determination.
So what were you doing then in all these years? Like
I am instructed, my lords, that they have been pursuing this matter.
19, 3 permissions were given, 11, 10, 11, 15, 16, 17, 19, 22, 23.
Absolutely. Whatever lordships had asked yesterday, I express the same concern. I'm informed and instructed that they had pursued the matter. She is an illiterate woman. She had instructed her lawyers to file necessary applications. It wasn't filed. Now the case has recently been taken over by a new counsel from Tura. He's the one who pursued this and filed the application under 151. And it's not that they were not heard. It is not an ex parte order, my lords. They filed an objection. They have stated so in their own petition. Just a moment. Kindly have page 8. Para 13.
Yes.
That on receipt of the notice from the court, the petitioner filed his objection against such illegal exercise of jurisdiction by the court. This is the 151 application against which they filed an objection. That objection is also not on record. So the parties were heard. In fact, my lords, in the body of the order, which is at
where's the
13,
objection, Mr. Siddiqui? You didn't file it.
My lords, both the counsels are recorded here. Their presence is recorded.
Understood.
Because it is recorded in the evening order, my lord. Whatever I have said, it is in the evening order.
No, not that. You see, you come to court, and this is a matter where it's a revision application. You don't even need to file a memo. You know, you just have to submit. We just look at the records. What to please for a trial court. It's not original. We're not exercising original jurisdiction here. You've come against an order of the. You've come to 2 to 7.
They've come under 2 to 7. I'm not even going to the issue of whether it is an appealable order or not. We're not going to that. So I'll leave this for lordships. But at least, my lords, our rights need to be protected. If a suit is pending for 23 years or 26 years at present, my lords.
When can you file your bring on record added materials?
From Garo Hills, my lords. At least a week's time. Minimum a week's time.
Yes, sir. Yes, Ms. Siddiqui, you have anything to say?
But my lord, as per the custom of the... Yes, I'm saying that as per the custom of the shrine, the Mela should be held in the month of April. So by this process of filing the affidavit, it will take a long time.
April is already over.
Mela, not about the...
April is already over. April is already over, Mr. Siddiqui.
Let's take action in that.
See, we are May now. May we are...
Only one day is over, 3 days written.
See, May we are only on... today is... Oh, May is there. Sorry, today is 10th. So 1 week's time, we still have enough time in May.
Well, may I also point out, I have inquired from them whether this will create any sort of a difficulty. They said that date can be postponed.
No, I'm talking. See, the thing is that the only concern of the court that fine, a Mela or whoever holds it is a Mela is a Mela is for the public, right? Enjoyed every year. Why should your private dispute stand in the way? True. Because if it's a dargah or something, it's like a public space also. Okay. So if the Mela has been held every year consistently down the years, whoever's obtained permission, well and good. The Mela, there will be no untold, but the permission also specifically states that the holding the Mela will not, vest anybody with any right to claim the disputed property.
True, my lords, but this also, lordships, this has economic benefits which they are deriving for the last from 2004.
That the court knows without saying, because holding a Mela, who holds it, they will derive economic benefits. That is why it comes down to that. It's not a question of religious Mela. I think it becomes to a question of monetary gain. So that is why.
So it's just that
that's why you are resisting it also, because on that very point. It's not a question. If we had no objection, let them hold it. It doesn't, it has an implication title. What is there? Nothing.
Only thing, is that if it was premised on something independent, it was one thing. But when they've premised on the fact that
that's why we're allowing you some time to bring. See, we're allowing some time to bring on record. After hearing some length, it appears that certain materials which are necessary for proper adjudication of the matter have not been brought before the court, have not been placed for the court. Accordingly, Mr. SNL, counsel for the respondent, is allowed 1 week's time to bring the said materials before the court by way of an affidavit list on 14th. No, sorry, list on today's 10th, 17th May.
Item number 2. Yes. Item number 2.
Whichever let the 14th Mela be taken out. On the 14th, the Mela is there. Let it continue only for 1 day at least, my lord. Let him give his reply.
No.
Let there be Mela. What is
no, Mr. Siddiqui, if the court satisfied that they would have come with clean hands, we have no problem adjudicating. It might go either way. But if we feel that it has stopped the court from appreciating the matter correct perspective, sorry, interim orders are called for.
Lordships are placing on the 17th. I won't be here. May I have it on the 16th?
16th.
Prepone it to a day. Highly pledged.
Yes, Mr.
After the disbursement of the 50% amount, respondent number 40 died recently. And
40 died in the withdrawed amount.
He has already withdrawn the amount.
Then?
After withdrawal, he died. He is implemented as respondent number 40 in the related appeal. And
he withdrew the amount and then he died.
After
It's
that,
not,
he
it's not
died.
pending before the special registrar also anymore.
No, nothing is pending. Only before this court, he is implemented as respondent number
40.
40.
Do you have any objection to subscription?
It appears to be within time.
Within time, and moreover, death is registered.
At least thankfully he could enjoy the money before he died.
Yes, he could. No, the second generation which started dying.
I say this within time because Lordship said limitation will not be a bar.
It will not be a bar because a reference has to be answered whether it's barred by time or not.
Only the death should be registered. So we have ensured that death is registered.
This is an application, Miss Case FA number 11 2023 in FA number 1 2022. This is an application for substitution of the name of the deceased respondent number 40 in the connected first appeal. Stop scene who expired on 24/1/2023. Stop. And who's going to 2023 stop peruse the application. The same is within time, and there's no objection from the counsel for the respondent. Accordingly, next paragraph, the name of the applicant, Simiti Airi Hun Nongrum, the daughter of the deceased respondent, shall be substituted in his place. Stop. Registry to make necessary corrections. This case disposed of. In the main case, in view of the order passed, miss case also. Huh?
Only miss case is listed.
Yes, only miss case is listed. In view of the order passed, it's also registry to correct the cost title. To amend the cost title, sorry. Yes.
Main list item number 1.
What is this?
These were the, my lord, connected matters for the Khetadawa school, my lord, if lordship remembers. They were
ask for comprehensive report.
What happened is that the inquiry report, when the preliminary inquiry has started, the commission secretary has fixed the date on the 5th April.
Where's the order for asking for the inquiry?
This order dated
Where is it?
7/2.
How much?
7/2.
How much time was given?
3 months time was given.
Now we are sitting on?
And now it's May, Your Lordship. And in the yes.
3 days over expired.
Yes, so 3 months expired today. Yes.
So you the report's ready.
What happened that on 5th April, he was relieved from holding the charge of education department as commission secretary.
On
the 5th April,
yes,
he has been relieved from holding the charge of commission secretary of education department. So now the new commission secretary has to step into the shoe of the Tiwari because it has been given by name.
Some shoe of who that? Who's that?
This Tiwari. So the
Who's
new
Tiwari?
That is commission secretary.
Who's not supposed to know? Doesn't know the name. Say unto the earlier commission secretary education.
It was given by name, Your Lordship.
Yes. Where's that name? Where's the order?
The order is
let him complete it. He's been given by name.
So that's a little confusion. The court may pass necessary order because now.
Then where's the application? Is it ready?
It was, I think, the copy.
No, is an inquiry report? Is it underway or has not been started at all?
Just
Inquiry.
started. Just started. It was started.
Then where's the miss application for extension of time?
That because now we are a little confused because we couldn't file it because who will sign the affidavit? So there was a little confusion. Yes.
Doesn't matter whoever steps the issues. You have to make the prayer. How will you this? You see, asking for a modification the early order also. That since the commission secretary has changed, that maybe the new one should be allowed to complete the matter, and that secondly that the inquiry that has been done within that time has given by the court. So where's the application?
Because we thought we'll file it, but we are a little confused. Who will
What
sign
we
the
thought
affidavit?
we'll file it?
who will sign the affidavit? So there was little confusion on our part, so we could not file the.
You have a top advocate general. You have how many additional advocate generals? How many additional advocate generals you have?
We have 4 additional.
4 additional advocate generals. 1 advocate general.
Yes.
How many senior government advocates?
We have 4 additional advocate general. Yes.
Yes. Then how many senior government advocates?
There are 2.
And how many additional senior government advocates?
Senior government, 2 senior government advocates.
No. How many additional government? How many additional senior government advocates?
There are 2.
2. That means you have 1, 4, 2 who are senior in the profession, correct?
Yes.
And they do no advice could be given in the simple thing like this.
So anyway, I was just instructed that the application for the extension of time is ready. Also, I may be given just.
Who instructed you?
We will move the application.
So this is absurd, Mr. Kumar.
We have to move the application. We have to move the application.
Should we make some observations? You are top brass from top to bottom, and you can't file a simple application for extension of time for completed inquiry.
If we'll be filing if record will be filing during the course of the day, or just give me 1 day's time. I'll just file it for the extension of time. I'm so sorry.
Mr. H. Abraham submitted due to inadvertence an application, appropriate application for extension of the time allowed for inquiry by directed for inquiry by this court by order date 7/2/2023 could not be filed. He please was allowed 1 week's time to file the same.
Hello, please, Your Lordship.
Item 1 to 6.
1 to
1 to 6.
Very absurd.
1 to 7. 1 to 7.
Yes.
Item 8.
You for the petitioner?
Well, Union's affidavit is outstanding. The cantonment had filed their affidavit. They had obtained a receipt.
1 and 2 is you filed. What about cantonment?
Cantonment is filed.
3 and? And Mr. Shulai for 5.
We filed, Your Lordship.
MS, how much more time? MSS Rumthaw Vice so and so. For to place phones allowed 2 weeks further time to file affidavit. What about state? No affidavit.
We filed, Your Lordship. We already
the other respondents, the other ones submit that the response will file the same on record is just after 2 weeks.
8-9, same, Your Lordship.
Tally.
Apply, Your Lordship.
10.
May it please, Your Lordship. Your Lordship, I'm praying for more time to file the affidavit in opposition in this matter, Your Lordship. Some clarification has been sought from the department.
MSZ in Omkari prays for a lot further. How much time?
2 weeks time, Your Lordship.
2 weeks time to file affidavit.
Obliged, Your Lordship.
11.
Please, Lordship. This matter I have filed in the affidavit of service to bring on record that private respondent of our court has received the notice, Lordship. We have enclosed the annexure 1 of the affidavit of service. This is produced by the superintendent of the postmaster. Till now, no one has appeared.
This is for continuation of delay, Lordship.
We'll condone the delay. Then what's the matter about? This application of condonation. How many days, Mr. Yes, this is an application on a section for condonation of a delay of 50 days in preferring the judgment, in preferring a review petition against the order judgment dated 2/12/2022, passed in WPC number 321 of 2021. Stop. Mr. S. Deb is present on behalf of the respondents 1, 2, and 3. It has been submitted and also filed an affidavit that the prior respondent number 4 has been served, but none has appeared on their behalf today. Stop. For the good grounds shown in the condonation application, the miscase or the instant miscase stands allowed, and the delay in preferring in filing the petition is condoned. Yes, miscase disposed of. Where's the main case?
Main case is there.
Ready today?
Next day, Lordship.
Okay. No doubt. In view of the order passed in this case, also this review petition is to be taken up for consideration just after 1 week.
Lordship.
Okay.
First place, Lordship.
12.
Meet please, Your
Yes.
May I please, Your Lordship? Lordship, I have received the copy yesterday itself, Lordship. Kindly allow me.
You're appearing for whom?
I'm appearing from J.C. Gaur.
Who GC Gaur?
The counsel is from Guwahati, Lordship.
You have received what?
A copy of affidavit, Lordship.
See, the thing is that, let just apprise the councils appearing election matters. That is akin to CPC, and whoever appears in it, you have to file a hazira in the morning to show the appearance. And a separate file is being maintained for that, so also for the respondents. It's like a trial. And so when you in the morning before you come, your hazira has to be filed before the court master to say that the councils for so and so are present in court today. Just like you do in a trial court, in a trial, so also the respondents has been filed haziras. You file haziras first for your appearance, as we won't take up the matter. So we record absence otherwise. Haziras will be filed. All the procedures will be exactly as the Act provides that it's not repugnant to CPC. All the procedures provided should come there, because it's involved even taking evidence.
Milord,
production of witnesses.
Guwahati High Court rules will also apply, Milord. If
That is besides the point, Mr. RP General. But at least if haziras to be filed.
Milord, one requirement is, Milord, that the petition has to be filed by the person himself. He can't file it through lawyer. He can't file it through lawyer. The petition has to be presented by the candidate or the elector before this honorable court.
For the hazira?
The matter will go even for filing petition, Milord.
Filing petition, yes. I mean, even for hazira, they have to file hazira to show that you're present in court.
Yes, Milord. Yes.
For every day.
This hazira is required. Every day.
It's not akin to any other proceeding.
It's not akin to any other proceeding, Milord.
Yes?
Milord, and they have sought.
Yes? They have sought what?
They have sought condonation of delay in filing the election petition, Milord. This is not condonable. I have given, last time I placed 2 judgments.
Let them file hazira first, then we take up the matter.
End of the court.
Yes, Milord.
Last time the matter came up, this matter was alerted to the councils. Election petitions stand a different footing altogether. You kindly read the provisions of the Representing People's Act, and also how the procedure is conducted.
But not this method also end of the board, election method.
Why you all?
14.
It's not that you all amateurs or something.
Sorry.
Lordship, I am appearing for item number 14. Affidavit is yet to be filed.
Please, Your Lordship, I beg for further 3 weeks' time, Your Lordship.
This is 2023. Okay. MS Ramsha pays for the 3 weeks time to file affidavit. Yes. Maintain file. You have to maintain a file. You have to maintain the file, hazira file. Verify one every time. And you have to give some training if you do. An idea.
15.
Praying for further 3 weeks time to obtain.
Why, Mr. What's the matter about?
Fresh matter.
This is regarding one particular notification which
fixation of the fixation of the gratuity as per the.
Oh, there's a second round litigation.
Yes, it's only been moved from the last one. For some
yes, Mr. S. Deb, please consult for the 3 weeks time to file. Affidavit of sale. Yes, thereafter.
First place, Lordship.
Hearing 16.
May I please, Lordship? My Lord, I am before this honourable court for the violation of Dikki Vasu's judgment, my Lord, in a contempt proceeding, my Lord. The law is settled, my Lord. Is it, my Lord?
Against whom the contempt?
It is against the IO and the OC, my Lord. What happened, my Lord? On 4th August 2015, my Lord.
On
4th August 2015.
When was this filed, Mr. Day?
This was filed in the year 2015, my Lord.
This is the size of the order file. It's These are orders passed in the case. Nothing happened from that time.
No, my lord, nothing has happened. It was heard by Justice More. Then again, an inquiry report which was not given to us, my lord. Then we have to apply for the inquiry report and all. Then we finally rejoined.
Give me the exact the parts you said, are in violation of the order of the Supreme Court in this.
Yeah, I will just give the background. Then I'll come to the law directly, my lord.
Okay.
Well, on 4th August 2015 at 7:30 p.m., my lord.
Yes. On 4th August.
4th August 2015 at 7:30 p.m., my lord. I'm the mother, my lord, and my son alleged that he hanged himself in the lockup of the police station, my lord. My lord.
Has he been compensated?
No, my lord. Nothing.
2015.
2015, my lord.
He's not been compensated.
No, my lord.
It does not figure in the list of those custodial debts.
It is figured, my lord. It is figured.
I mean, he's one of the persons there.
He's one of the persons.
He's recorded. Okay.
Yes. Now, my lord, in 2015, on 4th August at 7:30 p.m., my lord, I have received an information from my relative that I was directed to appear before the police station at 7:30, my lord, p.m. So I rushed to the police station. Then I saw my daughter-in-law was crying outside the police station, and one of the police officers informed me that my son has hanged inside the locker. The respondent, they have manipulated the documents to show that when I was arrested, and actually when I was arrested, it has come out from the inquiry report, my lord. At 3:30 p.m., my lord, my son was handed over to the IU. After he was arrested.
He was arrested which date? 4/8 only.
On 4th.
Arrested at what time?
As per the inquiry, it is 3:30 p.m., my lord. But as per the GD entry, they have shown him to be arrested at 6:30 to cover up their misdeed, my lord.
As per GD entry?
They have shown 6:30. And in an inquiry report, it is very clear, my lord, that the GD was manipulated, my lord.
Yes.
So, my lord, on that day, I went to the police station. I was not allowed to see my son's dead body. On 5th, my lord, dead body was handed over to us. A naked dead body was handed over to us. Not even a piece of cloth was.
5th, 8th was handed over to you.
Yes, my lord.
Where did this happen?
Juwai police station.
Juwai, yes, okay.
And there was an injury mark, my lord, in the body of the.
Yes.
My son.
Was post-mortem conducted, inquest related?
Yes, everything
submitted
was done.
HRC, videography done, everything.
We are not sure about the videography, my lord, whether it was done or not. But post-mortem was conducted.
There's certain
norms.
criteria.
Yes.
Yeah, the norms which have to be followed.
Yes.
Suppose in case of any unnatural custodial death,
my lord.
I mean there is a preset. That one copy has to be an HRC.
Probably they have followed, but we have no documents to say, my lord, whether it was done or not. I'm not saying whether it was done or not. It was not done, my lord. On 5th, my lord, a naked body was given to us after post-mortem. We saw the dead body. There was an injury marks in the dead body. And
what was the age of the deceased?
24, 25, my lord.
Okay.
Now, my lord, after all this issue happened, my lord, we filed a application before the OC to supply us the FIR copy on the basis of which my son was arrested and arrest memo and all. Nothing was supplied. We came to this honorable court. This honorable court passed an order to supply us the documents. Then the document was furnished to us. Then only we came to know, my lord, what has exactly happened. On 14 August, my lord, I have received a communication from the police department that an inquiry will be conducted by the DSP, PCM,
yes,
which is annexure 6, my lord, page 40 of my writ petition.
14/8.
40. On 14th August, I have received the information, my lord. From here, the case, my lord, comes into existence, my lord.
Where is that annexure?
Annexure 6, page 40.
Excuse me.
Hello, got it, my lord?
Walala Nongklau is the mother.
Yeah, Walala Nongklau is the mother.
Yes.
Now, my lord, this is the letter which was sent to me by DSP PCM, who was conducting the inquiry into the death of my son. Now, this letter says, my lord, with reference to the subject cited above, and with due respect, I beg to inform Your Honor, that the Superintendent of Police, West Jaintia Hill District, White DO number so and so, dated so and so, has ordered an inquiry to be conducted by the undersigned relating with the unfortunate date of Clifford Nongklau on so and so at Joy Police Station. The following points are to be inquired: circumstances which led to the death, lapse if any, whether procedure were followed as per the law and direction circular, etc. So this was, my lord, the inquiry which was supposed to be carried on. Now, my lord, may kindly come to the next page, page 41, Annexure 7. Annexure 7 speaks about, my lord, 2 constable who was in sentry duty was suspended.
This 48 on the day of the death.
Page 41.
On the date of the death only.
Yeah. They were suspended, my lord.
In a theft case?
In a theft case, my lord.
Yes.
Now, my page 43. This is the letter issued by the Undersecretary to the Government of Meghalaya, page 43. Letter dated 5th October 2015. This is a letter which was written by the Undersecretary to the Government of Meghalaya to the Undersecretary to the Government of Meghalaya Home Police Department, my lord. And they have, in reference to my son's death, my lord, they have issued this letter. With reference to the subjects indicated above, I am directed to enclose here with a copy of the letter dated so and so, along with a copy of the magistrate inquiry report received from District Magistrate, West Jaintia Hills District, Joy, which is self-explanatory. In connection with this matter, it is requested that follow-up action may kindly be taken from your end with Office of the Director General of Police to initiate action against the police person responsible for the lapse leading to the death of so and so. So this letter was issued to the police department to initiate departmental proceeding against the people who was responsible for the death of my son. Now, my lord, may kindly come to the charges. Charges is in page 47, my lord. Page 47.
Page 47.
Page 47, my lord. This letter was issued to the SI D. Shalam of Joy Police Station, my lord. He was the IO of the case, my lord.
Show cause notice.
Show cause notice, my lord. 3 charges was framed, my lord, against of him. So the inquiry report is there in my rejoinder, my lord. First, before I go to the inquiry report,
read the articles first.
Oh, my lord. My lord, you are hereby directed to explain as to why and of the penalties mentioned in section 71.
The charge.
The charge, my lord. On so and so date, Srimati so and so, wife of Clifford Nongklau, submitted a written complaint alleging that on so and so date, some police personnel led by you of Joy Police Station went to her house and took her forcefully to the police station, and also she alleged that you had threatened her with dire consequences. Now, charge 2, as per the copy of the arrest memo and seizure list prepared by you, the arrest memo did not bear the signature of the arrested person, Clifford Nongklau, and also the time. The place of seizure did not mention the seizure list, and the copy of the same was not provided to the person, Srimati so and so, and also her signature was not mentioned in the seizure list, which is completely lapse of your on your part of investigation. Now, charge number 3, my lord, is important. Section 41B CRPC laid down the procedure for arrest of the person, and also the Honorable Supreme Court's order in DK Basu versus State of West Bengal, which has laid the procedure to be followed as arresting a person, but you fail to follow. That is the case, my lord.
Okay. So that means against this person is his name is S.D. Chalam.
Yes, my lord.
So now he is represented here.
Yes, my lord.
The sole person.
No, no, there's two. My officer in charge is also there, my lord. Now,
On
my
private
lord,
engagement.
my lord.
Yes. Yes, okay.
Now, my lord, after this, my lord, what happened? In the department proceeding, they was found to be guilty, my lord, and they was punished, my lord. The law which I am relying on, my lord, is DK Basu, my lord. Can we come to DK Basu before I go to the inquiry report? Is to 1997.
You didn't give the list of books.
So, till the book reads, my lord, I will read the inquiry report, my lord. Is it my? Before I go to the inquiry report, my lord, I will like to take my lord to the arrest memo, to the GD entries, my lord. That is, they have filed their affidavit, my lord. In the affidavit, they have enclosed the GD entry. In March 2016, they have filed the affidavit, and this was filed by D. Chalam.
D. Chalam.
Page 11, my lord. Let us see from page 11. Yeah.
Who teaches Tandram?
My lord.
Respondent number 1.
Yes, yes.
Then where's D. Chalam? D. Chalam number 2.
Yes, my lord.
Okay. Yes, page
11, my lord.
Yes.
My lord, may kindly see from page 11, from 10 a.m. the entries are started, my lord. 10 a.m.
Yes. Now force personnel is.
Yes. Now force personnel has been deputed for so and so, then so and so transfers, so and so, so and so. If my lord may kindly come to 3 p.m. my lord. My lord may kindly see their vehicle checking was conducted and all.
3 p.m. now deputy SF allowance so conduct vehicle checking or joy bypass road department vehicle number.
Yes.
Okay, then.
Yes. Now my lord, at 3 p.m. nothing has been entered that some people has gone, some police personnel has gone to arrest Clifford Nongclaw. No mention has been made. Now at 4 p.m. my lord, so and so has arrived at the police station and took charge as a sentry duty for the next 4 hours at 4 p.m. Now my lord may kindly see at 6 p.m. no untoward incident reported as so and so during the last 2 hours.
Yes.
Now if my lord come to 6:30 p.m. my lord, 6:30 my lord, they are saying suspect brought in.
Now so and so Nicola.
Now so and so produce one suspect, Sri Clifford Nongclaw, son of Walana Nongclaw of so and so in connection with PS case number so and so, and handed over the above mentioned suspected to SI D. Chalam for questioning and necessary action. Now my lord, interestingly, the GD, when a police leave the police station, GD has to enter, my lord. Nothing has been mentioned. Suddenly an accused was brought at 6:30 p.m. Prior to this, no entry was made. Who has gone, under whose command?
No, that also it is not. It's anyway. You continue.
My lord.
We will come to that. I mean, we will get to GD entries, and on what basis is made sometimes, because sometimes it's not possible to anticipate something. Anyway.
No, it is not anticipate, my lord. It is some people who has gone to arrest me.
How is he going to arrest? Produce a suspect. Anyway, let's continue. Yes.
Now, my lord, can you see?
6:30 suspect. Okay.
Yes.
This is the GD entries.
Yes.
Yes.
Now, there is, if my lord see the serial, the timings, till 7:55 p.m. my lord, so and so arrived at the police station on being called by the OC. 7:55. Whereas I was called at 7:30, my lord. Now 8:10 p.m. so and so informed me that one person in the lockup has committed suicide after being verified by so and so. 8:10.
So he, okay. Right, next.
Now, my lord, may kindly see the rejoinder that I have filed, my lord. Rejoinder dated 18 March 2016. Annexure 1, page 9.
18 March?
Yes, my 2016. I filed my rejoinder where inquiry report was brought.
Okay. You sure 18 March is not 8/11? 82. Just check the date.
Maybe 11 March 2016.
11 March. Let's see. This is a rejoinder. This joint effort of the petition against an opposition dated 18 March is filed on 8/11/2016.
Yes, my lord. I'm sorry, my lord.
Yes. Okay.
Yes, my lord. Now, my lord, may kindly come to Annexure 1, page 9, my lord.
Yes.
Now, I would like to read from serial number 6, my lord. On so and so, I have recorded the statement of the police personnel, namely so and so, and so and so. Inspector T.J. Sajjem, S.I. D. Shalam, S.I.A. Wala, UBC P.W. Lamare, and others, my lord. The copy of the statement are marked as annexure so and so, so and so. During the recording of the statement, Inspector T.J. Sajjem submit as certified copies of extract of the GD dated so and so of Joy Police Station, while Chalam submitted a copy of the arrest memo of Clifford Snowcloud and a copy of the scissor list dated so and so. The enclosure are marked as annexure so and so, so and so, and so, respectively. Then my lord, A. Sinha and his team said that they handed over Clifford Snowcloud to officer in charge, Inspector T.J. Sajjem, at 3:15 p.m. on so and so date.
Okay.
Whereas the GD, my lord, speak otherwise, my lord.
6. Yes.
Now, my lord, may kindly come direct to serial number 10, my lord. The report, the next page.
Yes.
On 20th August 2015, I have recorded the statement of Walana Nauklau at her house at so and so. Simultaneously, I have recorded the statement of so and so in the same place. Copy of the statement as marked as so and so as enclosed herewith. It is worth to note that so and so stated that the police came to her house at around so and so on 4/8/2015. The police neither handed over the scissor memo or her gold finger ring, nor informed her regarding the arrest of her husband. The police went at 3:30, and my son was already my husband and the wife's son, the petitioner's son, was already in the thana, but they have never informed. Whereas the police came to the house, my lord. Now, my lord, may kindly come to serial number 12 now. On the 27/8/2015 morning, I recorded the statement of UTP so and so. All these are UTPs, my lord. All stated that Clifford Nauklau was already in the lockup when they were lodged there.
So when were they lodged?
My lord, they
so
was lodged probably on the 4th.
No, what time?
Timing they have not mentioned.
Because your whole case you're hinging on the time.
Yes.
That you're saying that the records have been doctored. The GD entry has been doctored to say that he was arrested at 6:30, and so but then you have to have supporting. Now these two people. This is the inquiry report.
This is the inquiry report.
Then what about the GD entries regarding these people when they were interned or arrested?
Nothing mentioned in the GD.
No, that doesn't matter. But the things that
now, my
nothing
lord,
there.
If my lord is wanting to know the timing, my lord,
because
that time has been mentioned, my lord, by the police personnel who has handed over Clifford Nauklau to the IO. It is mentioned in para 6, my lord.
No, that's fine, that's 3:15. But these people said on 27/8 on morning recorded statement of UTPs,
Yes.
Ricky Suting and Rishi Gatpo so and so and so, or stated that 3 Clifford Knockout was already in lockup. Is it really relevant, this one? They might.
Why I'm trying to show, my lord, that these people was also present in the lockup. Now, the allegation is this, that my son has committed suicide in the presence of 11 to 15 people.
In the toilet?
No, not in the toilet, my lord. In the main gate of the lockup, my lord. That is my case, my lord.
He committed suicide in the main gate of the lockup?
Yes, my lord. It's not in the toilet, my lord.
Okay.
Now, my lord, may kindly see the lapses now. In para 16, they have mentioned.
Okay.
On perusal of the statement of the person examined and the provision laid down in CRPC as well as the circulars and DK Vasu's guideline, the following are the lapses noticed. The apprehended person, Sri Clifford Knockla, was handed over by so-and-so and his team to Inspector T.J. Sajjam of Joy Police Station on so-and-so date at 3:15 p.m. Now, this is the statement given by the police who has apprehended him.
Yes.
But the entry in the GD was shown as 6:30 p.m.
Yes.
Now, next page, my lord, page 11.
10 or 11?
No. Sorry, my lord, it's 2, my lord. It's 16, para 2. Para 1 I have already read. Para 2. The close relatives of the apprehended person, Clifford Knockla, that is his wife or his mother, was not informed that he was apprehended. As a matter of fact, as per DK Basu's guideline, the arrest should be informed to the close relatives as far as practicable. Whereas Section 50A say that every police personnel or other person making an arrest shall forthwith give the information. Similar circular dated so and so issued by the Director General of Police reiterate the same subject, my lord. So it was already in the notice of the police personnel. The circular are already there, my lord, in the police station, my lord. But they have not complied with the circular, neither they have complied with DK Basu. Now, my lord, serial number 3. As per the copy of the arrest memo and seizure list submitted by so-and-so, the arrest memo did not bear the signature of the arrest person, Sri Clifford Knockla. Similarly, the seizure list did not mention the time of seizure, the place of seizure, and it appears that the copy of the seizure list was not provided to the person so-and-so since her signature was not seen in the seizure list. The apprehended person, Clifford Knockla, was not sent for medical examination before lodging at lockup. Of course, Section 54 doesn't say it. So, we are not interested on that part, my lord. Now, my lord, we kindly see the structure. Serial number 17, my lord, para 17.
Yes.
Now, my lord, it is only 6.10 feet, my lord. The height. And that is the main gate, my lord.
No, I don't understand this. Just the lockup at Joy, 1 second, the lockup at Joy Police Station does not look healthy or safe because cells are without any ventilation. Okay. Similarly, since it's not provided CCTV, it does not look safe at all. The iron gates are 6 feet 10 inches high, so UTP can hang from the iron gate only. The first case suicide in the lockup was on 23/13, and secondly on 4/2015, UTPs hang themselves from iron gate. Where is iron gate?
It is the main gate, my lord. It is where the person is pushed into the lockup. That is the only gate, my lord, in UI.
Is it reflected in the inquiry that is in the main gate that he committed suicide, right? That means, you mean to say that it's in the lockup in the police station?
Yes, my lord.
Correct?
Yes, my lord.
Police station lockup, you can see from where the IO sits or the OC sits, it's in plain sight.
Sentry should have been there, my lord.
Not sentry, whatever. So you mean that lockup police station, in that bar there, in plain sight of other UTPs, he hanged himself?
Yes, my lord. That is
not a question of that he went to the toilet and hanged himself.
No, my lord.
Does not appear anywhere.
No. There is no toilet even, my lord, in the lockup. So this is the case, my lord.
Of course, there's a toilet in lockup. Who says there's no toilet in lockup?
No, my lord. In Joy Police Station, where I was told, my lord, that at that point of time, my lord, inside the lockup, they used to be taken outside, my lord, for attending a natural call, my lord. That was what I was told, my lord. I don't know if it was there. So this is the case, my lord, where in 6 feet gate, my lord, my son, who was almost 5.11, he commits suicide. Allegedly that he has torn his banyan, and from the banyan he has hanged himself, my lord. Now, my lord, we kindly see the judgment now, my lord.
One second. So you're not saying that he died due to police torture, no?
No, because there was an injury mark in the body.
No, injury mark can be from anywhere. Even while being apprehended, also while fleeing, these things we cannot ascribe any kind of grave. Let's say that injury mark is the cause of the custodial. But your main thrust in this is that person who's taken into custody.
Yes.
The parameters and criteria as prescribed were not followed.
Yes.
And so since they were not followed,
yes, my lord,
it resulted in the death of the person.
Yes, my lord. If in case, my lord, they would have followed the procedure, at least that cloud which is in my mind, my lord, that has been cleared. 330,
But the cloud's been cleared by the inquiry report itself. See what it says. It says that yes, it corroborates what he said. Yes, he said that lapses, if any. Says yes, the lapses. And what was the punishment given to them, Mr. Chakravarti?
I don't know.
Some increments were stopped.
So that is one, that is their finding, and they have never challenged that, saying that
No, why should they challenge that? Because this it's been advised by the disciplinary authority itself.
No, if they was aggrieved.
Okay, then come to the what do you seek to achieve by contempt?
There was also a ministerial inquiry. There was a ministerial inquiry.
What year?
1997, volume 1. Page 416.
You never filed for compensation?
My lord, here, my lord,
when after this thing happened.
Can I just say something with my experience, my lord? We have seen that even the medical reports are, my lord, manipulated, my lord. And this honorable court, my lord, has come to a finding that even the medical report was manipulated. The medical report, the exact...
In this case?
Not in this case, my lord. In Balsran case, I am saying, my lord, Meena Asmara.
That's a one-off case.
No, my lord.
You cannot see across the board that medical reports manipulated. You have to give credit also. Whatever cause of death. Now the thing is that what this court is trying to, where are we getting in this contempt application? What do you want?
No, my lord. The law has already been prescribed, my lord. And
what's the law laid down? That they should?
The para 36, my lord.
Yes.
Before I go to para 36, my lord, I would like to take my lord to para 35, page 435.
No, 36 gives the time, place of arrest, so on and so forth, and it should be recorded. Those things, right?
Now
if I'm not wrong.
Yes.
Where's 36?
35, my lord. 35 says about
requirements.
Now, if it is not followed, then what is the penalty can be imposed, my lord? Page 436, my lord. Para 36. Failure to comply with the requirements herein above mentioned shall, apart from the rendering the office official...
Para 36, okay.
My lord, got it?
Yes.
Failure to comply with the requirements herein above mentioned shall, apart from rendering the official concerned liable for department action, also render him liable to be punished for contempt of court, and the proceeding for the contempt of court may be initiated in any high court of the country.
Yeah, that's what's what to put him in imprisonment for 1 month.
Sorry, my lord, I could not follow.
What do we do on contempt? What do we do? Punish him. The contempt is made out.
My lord,
put him in and fine.
As a citizen and as a victim that my son lost his life, my lord, I am before this honorable court. It is not this honorable court to decide, my lord.
What do you want? You want to vindicate your compensation case is still pending, correct?
My lord, compensation.
You can bring all these things because now the division bench is sitting examining each and every custodial death that happened after 2012. Okay, and so what are the lapses that occurred in that particular case to determine the quantum of compensation also, and then if necessary, orders will be passed whereby corrective action will have to be taken. I am part of that bench also. I am very well aware that with regard to there have been 49 custodial deaths from 2012 till date. I mean till the Supreme Court passed the order for all the high courts to take sumo cognizance of custodial deaths. Now this is running in a parallel fashion.
So let it be kept pending, my lord, till the matter is disposed of.
then this matter it'll be like a parallel proceeding because it's being examined.
No, that is for the compensation, my lord. They will not.
No. It's not in compensation. There's some cases unnatural death because now you are aware of the scheme that there's a direction. There's a direction from the National Human Rights Commission where they frame criteria in the case of unnatural deaths, custodial deaths, and so forth. I think where Dr. Mosika, he's here.
My lord, what I have heard last
he's
time.
the amicus in the case.
I know, my lord. And what I was heard, my lord, for suicide, they are going to pay 5 lakh rupees.
No, this 5 lakhs is just a benchmark. But see, that's why this court is going to look at every point. We're giving the counsel the opportunity also to show to the court that these are the lapses that occurred. So what purpose will be served by us by going into go to parallel inquiry if we see that yes.
Not parallel inquiry, my lord. I am before this honourable court for contempt of court, my lord. That they have not followed this and the law already prescribed.
Let them decide a particular case, then we'll see.
My lord, let it come after.
Otherwise, this exercise is futile.
I'm on a different footing, my lord. But
you see, for vindication, something else.
It's not that
vindication, something else. It's relief is something else.
My lord, it's not that we are vindictive, my lord. That we are going to punish that.
What
but a message has to go.
Exercise your
a message has to go, my lord. Even thereafter, Mr. P.T. Sama has filed a case where a person was called and he was made to sit 24 hours in Thana, my lord. These things are still on.
After hearing at some length, the subject matter issue substantially is also at the moment being agitated in a PIL, sumoto PIL before this court, before the division bench of this court. Well, this is a matter after 4 weeks to await its outcome, because there's no point in coming coming to a finding. Finding will come what? I mean, we'll punish him for contempt. Contempt what?
Following the due process of
get a more substantial relief, by pursuing the other matter, by bringing these very facts before the court that in this particular case, this is what happened. These are things that have not been complied with. The conditions of the prisons are such. Conditions of prisons, so there's a PIL, there's a PIS.
We have made a mention before the division bench also to tag this matter.
So not to tag the matter. You don't have to tag the matter. You can find an affidavit in your case, bringing all these facts on the court. Why tag the matter?
Then I will do that, my lord.
That is up. We are not here to advise.
23.
Yes.
I would submit instead of 4 weeks, just
6 weeks.
6, 8,
6 weeks.
whatever. All right.
All right.
This is squarely covered, your lordship already noted, and the division bench also says that it should be extended to all the similarly situated petitions.
Read.
Yes, already noted by your
Disposal
lordship long back on
Your lordship, let it come up at the end of the board.
2/11/2022. Squarely covered, my lord.
2/11?
2/11/2022. Your lordship already noted. Because another 14 technical trade division bench has upheld and they are rejected.
No, yes, Mr. Dr. Mosika also said that
Covered.
Not covered when he has not made any serious objections. Let him come.
My lord.
$25. $25.
Yes. Start.
This
matter has been
we are
hanging around not really the course around your neck for.
Well, we are caught to the very peculiar situation.
Frequent situation.
He just informed us that he's no longer interested to have us engage in the matter. So perhaps he's seeking to.
Mr. Thapa, the court recused the matter also.
He sent us a message, my lord.
Send a message that even the court also is not interested in you change the court also, not only the council.
Otherwise, we were ready to do the hearing, but since we
you tell them you change don't change the council, change the court also, go some heads.
I don't know whether I'm in that capacity anymore or not, even to advise in that way.
No, it's just in jest, I'm saying.
Because we received a very categorical message from him saying that he wished to engage another council. So we said, fine. Since our name still reflects in the order, I found it proper to inform the court also.
What to do? He's brought all the records.
Otherwise, this matter.
He's at the final stages for the records.
Yes,
This is Mr. Paul was not available for many dates. That's the only thing. Because he was
last
away.
occasion, it was the respondent who sought time. Perhaps now that the orders are readily available in the internet, he must have seen that also. But in spite of that, my lord, he took that decision. Of course, we have no say over it.
Of course.
That is his wish. We can have it after 1 week. Let him.
Mr. Estapa submits at the bar that they have since been disengaged from the matter. Stop. As the petitioner is seeking alternate counsel. In this view, the matter is a matter of 2 weeks.
26.
Hello, the affidavit has shown the list. One is the gradation list, 2017. And other
1 second,
one
just
is-
before you start. Take a small break, 5 minutes. I try to avoid sitting for more than 1 hour and a half or 2 hours. It affects the back. Yes.
The annexures which the counsel for the respondent have given, it is the same annexure, only it's the question is whether the second list, the annexure B, is a merit list or not. Thing is that I have been given to understand that this is a kind of merit list only, because the respondent cannot deny that the serial number 1 in this list is not the senior most officer in the list. Similarly, the number at last.
Okay, first, wait, refer to affidavit of the estate. Filed when, numbers colony, this is 1/3/2023. Okay, right. 1/3/2023.
So,
okay, where's the list?
Page 5 of the...
Page 32.
Of the petition, yes.
R5.
Yes, ma'am.
Oh, wait, which one you want to show, Mr. Bora?
In the list, my lord, in the gradation list, first gradation list.
No, where, which paragraph, which affidavit, which page?
Page 23 of the writ petition.
No, you said the affidavit just now.
The affidavit, I'm looking at the affidavit, yes. Page 5 of the 6 of the affidavit, and 6 and 7. My name comes in page here, page 7. That is, here in this list, I'm shown at serial number 17, page 7.
Page 6.
And B Kundu is just above. And the
wait, okay, fine. Yes. Page 6, page
7
6
of the affidavit.
Okay, page 7. Number?
Serial number 17 is my name.
17, junior grade?
Yes, my lord. Imon Marap.
Junior grade, Imon, okay, or E Marap here. Okay, 17,
then,
right.
18 onward is
18, okay, 18.
18 is respondent 3 here. So the first batch who were promoted from respondent 3 to 8. Here it is from 18, serial 18, 19, 20. Serial number has been mistaken here up to Srimati Sheri Sadap. That is respondent 8 here. That was the first batch who were below me in the gradation list. They were promoted, and the second batch was respondent 9 to 13. They also in the same list from iron oil swell up to
number.
Here the number has been mistaken. After 17, 18, they have written 19. Should be 19. It has been written 13 here in the list. Should have been 19, 20. That way, but here the serial shown here again is 17, Sheri Shadab, in the list. But the original list.
No, I don't understand why you think it's wrong. It's
serial
going
number
serially, it's going seriatim. Say, oh yes. Ms. Connie, you seen this?
After 18, 13 has
after
been
Sergeant Paul
serial
18,
number.
It goes to 13, 14. How is this?
My lord, this is the
serial number has been mistaken.
No, kindly
After
see.
18,
Is Mr. RK General appearing here?
Yes.
See, Mr. RK General, see in page 7 of this affidavit filed by the state, you come to page 7, you come to like the last part of page 7, last 3 notes. See, it goes 11, 12, 13, 14, 15, 17, 18, the next 13, 14.
Your Lordship may have this matter tomorrow, my Lord. In the meantime,
Can you see?
With the record.
My lord, I
Yes,
the
Lordship.
copy scan.
You just have a. This is very strange.
I don't have, because my friend
senior
could
do not
not
have
give the
the
copy
copy
of
of
this
the
particular
affidavit.
affidavit.
He may not be able to answer your Lordship's query. Lordship may give me time, and till tomorrow this matter can be taken up.
tomorrow Your Lordship may take up this one tomorrow. I'll just check.
There's some discrepancy in there. Yes.
Tomorrow and day after I am
In
busy.
the I'll check.
Monday, next
We're
Monday.
going to Dhemaji.
Next Monday, 17th.
You're going to Dhemaji. Adjournment's taken before that. You're going to Dhemaji. I was wondering what you're doing, Dhemaji. Yes. List the matter on Monday for further order. Kindly. I wouldn't note down the discrepancy, but can you say page 7?
Yes.
He's correct.
Yes,
He's
I'll
13.
check. I'll check.
If my lord, I'll request the department to give the original copy.
No, yes. He gave. I think we have
Serial number,
We can see, my lord, what is the exact, because we have been given a photocopy of the.
what list is that? And it can't be like that.
Gradation list, my lord,
Yes.
which my
Gradation
referring to.
Monday.
Monday. No.
Oblige.
Suppose we're in. Yes, Mr. Sen.
This is the read petition my school is aggrieved by the assessment of damage and interest to losses by the Provident Fund Authority, my lord. Lordship will come, my lord. I'll take my lord to page. I'll start with my lord for annexure 10, my lord, which we are aggrieved. That is dated, my lord, at page 17, my lord. Annexure 10, page 17. Issued by the Assistant Regional Provident Fund Commissioner Shillong. To the school.
Lecture 10 page?
Page 70, 70.
70?
Yes, my lord.
That's 17. Okay.
Lawful. Now this is addressed to the school, madam.
This is 1512. Or was it
1512, my lord. 1512.
Okay.
Madam. 70. 70.
Yeah.
I think it is 72 in my page is okay. Let's start.
My lord, I have given to the correct one. 70, my lord. 70. Now, my lord, this is dated 15/12/21, addressed to the school, your lordship. Now, we say, my lord, whereas Loreto Convent is establishment covered under the Employees Provident Fund Act, such and such. Now, this is not disputed, my lord. We have covered, your lordships. Now, my lord, come to the, my lord, next para. And whereas under section 14B of the Act, where an employer makes default in payment of contribution of any charges, the commissioner is required to recover by way of penalty such damages, not exceeding the amount for the arrears and the rate damages at the rate specified in para 32A of the EPF scheme 1952, para 5 EPS 1995, 8A EDLI scheme such and such. Now less than now my lord, these are the, my lord, calculation. Now next paragraph is very important, your lordship. Now the scrutiny of the records maintained by the office of the for the remittances made by you during the period from 1496. Lordship will take note, my lord. 1496 to 31/3/2014. This is the period they have mentioned. So subsequently they have corrected it as 1496 to, my lord, 14/2000. I'll come to it later. Now this is the period they have mentioned. Shows that there are certain payments which were made after respective due dates, and the total amount by way of penalty amount and interest, such belated payment, are as hereunder. Now, my lord, under the provision of the Act, it is clear, my lord, if the contribution is not made in time, then they can collect, my lord, interest and by way of penalty, damages. I am not disputing that. They can do this, lordship. So, my lord, it is not a case of, my lord, non-payment of contribution. Contribution was paid not in time. They have discovered subsequently from their record the remittances were not paid in time but belatedly. So, they have imposed this cost and damages, but the period is important, your lordship, what I said. So
under 14B.
14B. So they have issued this shock cause, my lord, along with my lord, the relevant entries in the remittances book. Next page. Now, my lord, we'll come to page 75, your lordship, annexure 11. Now here they have corrected the period.
Okay. You're saying first they say it's for the period 14.
In the original shockers notice, they are saying it 1/4/1996
1996 to
31/3/2014.
2014 delayed payment. Shows that there are certain payments which were made after respective due dates and total amount by way of penalty and amount of interest such belief is as under. So you are given a total penalty of 1,66,000.
My lord, this is 16 lakhs.
Or 16,64,000, yes.
16,64,000.
Okay, 16.64 lakhs, okay.
Lordship, my lord.
For 16.64 lakhs penalty.
Lordship, this is penalty and interest.
Yeah, penalty plus interest.
Penalty and interest. Now, Lordship will come to page 75. Next are the, my lord, the evidence, the relevant part of the remittance book. Now, my lord, I'll take my lord to page 75. Now, 75, they have corrected the period. Whereas the date of hearing for the inquiry under section 14B EPF such and in respect Loreto Convent holding PF number such and such was fixed in 25/2 at such and such. Whereas none appeared on behalf of the employer in respect of the establishment, scheduled date and time of hearing, nor submitted any representation or paid for the grant. Now, providing reasonable opportunity to the employer to present the case along with the relevant record as called for. The case is adjourned to such and such date, and the employer in respect of the aforesaid establishment is directed to attend the inquiry on the aforesaid date before the Regional Provident Fund Commissioner, Regional Office, Shillong. Failure to attend the proceeding will result in ex parte order as adequate opportunity. Period of inquiry, Lordship will take note. 1097, wage period, my lord. These are called 1097 to 4/2007. This is the wage period for which, my lord, in fact, they had assessed the damage and interest.
Inquiry 10/197 to 4/07. Yes.
4/2007. Now, my lord, my case before the authority was that you could not have, for that period, you could not have, my lord, assessed me for damage and interest for that entire period.
Which period?
Because
96 to 14.
Lordship. One is 14, then subsequently stand corrected, my lord, from 1097 to 4/2007. Why? Because that period was already assessed, a case was filed before this court, and the intervention of the court matter was finally settled, payment was made. Now they had reopened that part also. So that I'll take your lordship now. My lord will kindly come to page 36.
Go back.
Yes, go back.
No, legible.
My lord, that is not, my lord. Ultimately, the findings, your lordship, that I have given a typed copy, my lord. Start at page 59. 59 is the finding, my lord, which was challenged before this court. I'll read it. Page 59, the typed copy.
Which challenged earlier time.
Lordship.
Yes.
Page 59, my lord. In the matter of inquiry proceeding for determination of interest under 7B and damage under section 14B. This also relates to, my lord, interest and damage only of the Act in respect of Mr. Loreto Convent, Dhanketi, Shillong for the period 1988 to June 2001.
2001, sorry.
Yes, March 98 to 2001.
Yes.
Whereas under section 66A, 6C of the Employees Provident Fund and Miscellaneous Provident Fund Act, read with paragraph 38 of the Employees Provident Fund Scheme 1952, paragraph 9(1) of the Employees Family Pension Scheme 71, paragraph 3(1) of the Employees Pension Scheme 1995, paragraph 8(1) of the Employees Deposit Link Insurance Scheme 1976, you are required to deposit Employees Provident Fund and Employees Pension administrative charges payable under section 17 of the Act to respective funds within 15 days of the close of the month in respect of your establishment, Loreto Convent School, Dhanketi, such and such. Whereas the employer, Loreto Convent, Dhanketi, Shillong, has failed to remit the statutory dues as stated above within due date for the period March 1988 to June 2001 as intimated by notice dated such and such. In this regard, the employer was given an opportunity to present their either in person or through authorized representative by issuing notice number such and such dated 18/10/2004 to attend the inquiry on 4/11/2004 at 11 a.m. on for 4/11/2004, such and such the principal of the school appears on behalf of the employer during the inquiry and submits the details of the deposit from 397/26/2001 for verification and necessary rectification of the schedule of penalty dated such and such. Accordingly, the schedule of penalty is rectified by deleting the penalties for the period 397 to 1097 and 2001, for which PF dues were paid within the due dates. Such principal of the school further referred to the central office circular dated such and such to consider their case for waiver reduction of the penalties. It is further submitted that the delay in depositing the statutory dues was due to the change in management and also cited financial constraints of the school to meet the penalties. However, the authorities' representative failed to submit any evidence, records related to the nature of change of management as well as financial constraint. Now, my lord, findings. During the inquiry, the authorized representative failed to submit any justified reason for delay committed in remittances of monthly statutory dues for the inquiry period, which fall within the ambit of the terms and conditions laid down under paragraph 32B of the Employees Provident Fund Scheme 1952, and warrants recommendation for consideration of waiver reduction of damages by Central Board of Trustees PFO. This justifies the levy of penal damages under section 14B and interest under section 7Q of the Act 1952. The prayer of the principal of the school is also examined in the light of the central office circular such and such, but the present case does not fit in issuing coverage memo dated such and such, and hence there is no change in quantum of penalty for the inquiry period. It is further confirmed that no penalty under section 14B has been levied for the period 382 to 282 in the light of the Honorable Supreme Court judgment related to educational institution. On consideration of the records placed before me and the submission made by the authorized representative of the employer during the inquiry in the light of my above findings, I have reason to affirm that the employer have failed to remit the dues under EPF MPI 1952 in the respective funds on or before the due dates in respect of the dues for the period March 88 to June 2001, as shown in the rectified schedule of penalties without valid reason. The total amount of interest and damages payable in respect of the belated payments for the period such and such, as per rectified schedule penalties, are given. So this is what amount has been attached, my lord. It altogether, my lord, damage and interest they have calculated as 7,36,002. Now after that they write, and whereas ID Singh such and such is empowered under section 14B of the Employees Provident Fund Act 1952 to determine the amount due from the employer as damages under section 14B in respect of the above said belated payment of statutory dues. Now therefore such and such person in exercise of the power conferred on me under section 14B of the Employees Provident Fund Act such rupees 7,35,652 as shown in the above table. Thus, the employer of Ms. Loreto Convent, Shillong, is directed to deposit an amount of rupees 7,36,002, being the interest under section 7Q, penal damages under section 14B of the Act within 14 days from the date of the case. So, such as now, these I have challenged.
You dated when, Mr. Sen?
This is dated, my lord, 9/12/2004. Bottom.
9/12/2004.
And the total amount was assessed, my lord, at 7,35,000. But they have rounded it to 7,36,000. So, my lord, then thereafter, my lord, the demand notice came. 6. Next paragraph, next page, your lordship. If lordship kindly comes to paragraph, page 63, the amount has been mentioned, and besides that, the period has been mentioned by has been mentioned from 388
to 621, 2001.
So this is for that period.
Okay.
Now, being agreed, my lord, I have challenged this by way of writ petition before this honorable court. Now, my lord, the judgment was rendered, my lord, on 12/8/2008. My lord, I'll just read it. It's not a very long order, shall I?
Yes.
Hard such and such. Number 2. In this writ petition, the petitioner is questioning the validity of order number such and such 7Q and 14B dated 19/10/2004 issued by the Assistant Provincial Fund Commissioner Shillong and demand notice dated 29/4/2005 issued by the same authority for payment of damages and interest under section 7Q and 14B of the Employees Provident Fund and Miscellaneous Act 52. By the impugned notice and order, a total sum of rupees 7,36,002 was sought to be realized from the petitioner for belated remittances of his contribution. There is no dispute at the bar that the penalty by way of interest and damages sought to be realized from the petitioner is to the extent of 100%. It may not be out of place to notice that the petitioner is a principal of the Loreto Convent, Shillong, and that as required by the provision of the Employees Provident Fund and Miscellaneous Provision in 1952, which is undoubtedly applicable to the institution in question, the petitioner is required to maintain Provident Fund accounts for all its employees. In the month of February 1997, the petitioner received notice dated such and such under section 14 of the Act from the respondent number 3 requiring her to deposit her contribution dues within 7 days. According to the petitioner, in compliance with this notice, her contribution was deposited in EPF amounts in the State Bank, and in the month of April 1988, she also transferred accumulated fund in Allahabad Bank to EPF account in the State Bank, which was duly communicated to respondent number 3 by letter dated 28/4/98. In the month of October 2022, the respondent number 3, however, initiated a proceeding against the petitioner under section 7A of the Act to ascertain as to whether all the dues have been paid. In course of inquiry, the petitioner explained the circumstances under which Provident Fund amounts were deposited in Allahabad Bank. Apparently dissatisfied with the explanation given by the petitioner, respondent number 3 by order dated such and such directed the petitioner to deposit a sum of rupees 6,01,018 being the balance due under various accounts within 15 days from the date of receipt of the order. The petitioner duly deposited the aforesaid amount by challan dated such and such and also intimated the same to respondent number 3 by her letter dated 17/12/2004. The respondent number 3, however, issued the notice dated 18/10/2004 under section 7Q and 14B of the Act, imposing interest and damages referred earlier. Then the learned senior counsel for the petitioner, drawing my attention to the decision of the Apex Court in such and such reported in AIR 2006 SC 1767, submits that damage imposed by the respondent number 3 upon the petitioner in terms of the aforesaid notice to the extent of 100% is highly excessive and contrary to the said decision of the Apex Court. In my judgment and order dated 1/7/2008, passed in such and such, in a case which is somewhat similar to the facts of this case, I have reduced the damage imposed upon the Don Bosco Technical School, Shillong from 100% to 25%. Needless to say, my aforesaid decision was passed in terms of the decision of the Apex Court in such and such. Therefore, there is no legal impediment in passing an order of the nature passed by me in such and such. The quantum of damage being reduced to 25% herein will be at the sum of rupees 7,36,668 by leaving the interest payable intact. For what has been stated in the foregoing, the writ petition is partly allowed. The damage imposed upon the petitioner, the order of rupees 7,35,658 by the impugned notice and order dated 9/12/2004 and 29/4/2005 shall stand reduced to the extent of 25%, that is rupees 1,83,914. The petitioner shall now pay 1,83,914.50 together with interest amounting to rupees 344.
Okay.
Respondents. Now, my lord, next page, your lordship will come 68, the challan. This amount I have deposited as directed by the court.
So this is for the period. It's from
this is the period from your lordship 388 to 6
March
88.
March 88 to
June 2001.
June 2000. Okay.
June 2001.
Yes.
So I have deposited. This is the challan. Then
Okay.
formal intimation and annexion 9, my lord. I have made a formal intimation also to the authority, Assistant Regional Provident Fund Commissioner, about the factum of depositing, my lord. My lord, that was also, my lord, lordship will take note. For that period also, my lord, it's not the contribution. Contribution was already paid. But because of belated payment, they assess
Damages.
interest and damages.
Now coming back to your case, the period of inquiry, first they said wrongly from 96 to 2014. Then they corrected it and said from 1/10/97 to 4/07. So the thing is that now what happens was 98 and 2001 in the middle.
My lord?
What happens at the period where they've paid the damages for 1988 to 88, no?
1988.
2001. What happens to that?
No,
That will be the period from 96 to 2001. What are you doing with that? Or rather, you did from 97, yes.
97.
Yes. So what? So why do you go back to 97?
Lordship, in our order, Lordship, the last judgment, the last page, Lordship, may I draw your attention?
No, I'm going to look. See, very simply put, now your period inquiry for, you said, okay, let's do 1/4/96 to 31/3/14, right? Yes. You corrected that, no, we won't do from that. When 17/6/2022, you said the period inquiry will come from 10/1/97 to 4/2007. Correct? Yes. To April 2007. Now, Mr. Sen has shown that there was a proceeding for the period 1988 to 2001. Okay? Yes. Now you have to take out this 88 and 2001 from this thing. 98, 88, so that means from, as it is, you're doing from 97. So 97, 2001, that means 4 years. Why are you clubbing it together again?
Lordship,
then the inquiry will just be from 2000 and it'll be from 2002, 2007, if any inquiry will be done.
And my lord, one thing perhaps they are saying, my lord, that provision I will show you. There is a provision which say in case of any escape amount, suppose in a notice some amount is not mentioned by mistake, either due to the misrepresentation by the SSC or by the authority, whatever it may be, there is a provision, they can issue a fresh notice. But there they have categorically mentioned that has to be done within 5 years. These were settled, my lord, way back in 2008 and all, yes. Finally, my lord, in 21. How can they?
Yes.
Lordship, my senior has rightly mentioned, it's means the escape amount can be taken into consideration. Lordship, in our order, Lordship, we have already reflected in our order.
Where?
It's page. Actually, Lordship, I think it's our final order, Lordship. It should be page
84.
86, I think.
This is in 84.
86, the final order, Lordship. The final order, Lordship, 86, page number, annexure 15, Lordship.
Yes, sure. Which is the other provision?
Lordship, page number, order, page number 87, Lordship. Page number 87. The submission made by the employer has been, last paragraph, it is like 1, 2.
Where are you reading?
Page number 87, that is page number 2 of the order, 85. Final order. 87.
87 is the last order. I come up and I thumb result so for the ordered amount of damages be paid. What are you reading?
Lordship,
85.
85. 85.
It might.
Now I'm given a corrected one.
Why didn't you give correct one before that? Yes.
85. 85. The last part, Lordship, the submission made by the employer.
Okay. Yes.
The submission made by the employer has been examined with reference to materials on record, rule position, and the laws laid down in this regard, and it has been found that for the wage month of 1097, it has been seen from the challan submitted that the belated payment of EPF dues pertain to the arrear payment of PF dues by the employer whose delay in payment was not taken into account in the previous demand notice, and hence there is no overlapping of damage dues. Lordship, we have already reflected in our order, Lordship. Further, from the contention made by the employer establishment, it is clear that there is a confusion between the assessment of PF dues under section 7A and penalty imposed for delay in payment of EPF dues as determination of the escaped amount under section 7C is only in relations to the assessment of PF dues made under Section 7E. As the current enquiry related to the damage only, wherein there has been actual delay in payment of PF dues for the present period of enquiry, and the amount of which has not been included in the previous demand notice dated dash, and also seen no documentary evidence has been submitted to show that the PF payment has been made on time in the contested period, the contention of the establishment is therefore rejected and the instant case is therefore closed. Lordship, we have taken into consideration, we have already checked the entire the dues which were being escaped, and thereafter we have calculated, Lordship.
One second. That earlier was closed, page 59 was closed on which date? The findings?
The findings were...
In that page 59, findings were closed on which? 92. What year was that?
94.
No, sorry. Which year was that? 59, where it was closed?
It was closed on 9/12/2004.
Then you've come back after this order is dated
21.
21. Then how do you 22? Now how do you explain that?
Lordship, it is when the system shows that the
We're not talking about a system. We're not talking about a machine. Then there's a human element. Suppose a system can generate something, but whether it's a decision of a person sitting in the chair. Okay, the system generates that at a certain point of time. Maybe there's been some escape revenue. Now, what is the limitation period for you to recover an amount? System can dig up anything.
7C.
Suppose you come to income tax. Now, system digs up that you didn't pay income tax, file the returns for the year 10 years ago. Can the income tax come up to you now?
Lordship, whatever we have mentioned in the order sheet, Lordship, we have.
No, it's not a question.
We have taken into consideration about 97 also, Lordship, and we have taken
Where the
all
affidavit?
the Lordship, in the order sheet we have already reflected. Lordship, we have already reflected. Thereafter, we have calculated, Lordship. The calculations also in.
No, what up with 7C? I have a problem.
7C, my lord. But before 7C, if you, my lord, kindly.
No, 1 second. No, I'm just
7A.
and on the dates only. You close that for that period. You close. You're not entitled to reopen it again. And if any breakaway periods are there, that you reassess. That's all. But not in this manner. That you'll come after how many years?
It's almost, my lord, going to be 18 years. 17 years.
Lordship, for the determination of escaped amount, there is no such thing, Lordship. Whereas an order, where an order determining the amount due from an employer under Section 7A or 7B has been passed, and if the officer who has passed the order has a reason to believe that that by reason of the omission or failure on the
Come to the last part. He may what?
He may, within a period of 5 years from the date of communication of the order passed under 7A or Section 7B, reopen the case and pass appropriate order redetermining the amount due from the employer in accordance with the provision of this Act.
Yes. So,
Lordship, here
it's not even shall. He may.
He may.
So the machine digs up something, escape some amount at that time. Now this officer sits there. Oh, very good. We reopen the case. Where are the reasons? Where are the reasons in the order that why we reopen the case? What are the cogent reasons they stated there? That you reopen the case, 7C allows this. Where is it there? Where is it in the order, in impugn order? The reasons for reopening the escape, the period of escape amount, like you say.
Lordship, period of escape amount when...
Where are the reasons? Under 7C. 7C is a provision that allows you, may within 5 years. Now you say that was done in 59. Not you, I mean your client. 2004 was a finding. Challenge in court. Don't forget that. Challenge in court, and what happened? Did you come to the court again to review the order?
No.
That penalty is wrong, that there's an escape amount. Did you take that into consideration? Or thrown out by machine only? Machines are throw out court orders also.
No, Lordship, we have
Then?
not.
Then can you factor in this amount that's already been decided?
Lordship, the amount which were the amounts were decided on whatever the.
No, look, every case has its own identity and life. Now this matter was settled in 2004. In 22, you reopened escape amounts, correct?
Yes.
What are did you take, where is it mentioned that they had gone to court in that order I want to see? Where is it mentioned that the penalty was initially fixed at 7 lakhs and then they had gone to court, WC number so and so, decided the court said, where is that in this order? Is this officer even aware that it had gone to court?
Yes, Lordship.
He was aware. Is it reflected in the order?
It is there, of course, my lord. On page 85.
He says gone to court.
We have pointed out that judgment.
Where? No, consideration means that it's gone. That's exactly that. The matter has gone to court. What is decided on that?
Nothing. Our contention we raised about the court, my lord, 85, point number 1.
No, consideration means what, Mr. Sen, means that it has gone to court. He's taken a conscious decision that even though it's gone to court, we're reopening this thing. That's what the court is trying to say.
No pending at all. No pending at all. My lord. And once it came to the court, my lord.
You prepare yourself. We are quashing this order.
Lordship, my lord.
Let her prepare.
My lord.
And let them do a fresh assessment minus those years which has been done.
Only other point, your lordship,
Yes.
regarding other period, my lord, of course, it is open to them to reassess.
Of course,
but then
that you cannot avoid.
One thing, my lord, 100% it cannot be, my lord. Without reason, how they can say 100%?
Let them first factor in. They'll not include the period from which after 22 for the period of damages or whatever delay in payment. Let them. This is just you convey to your people that the order is absolutely unsustainable. Okay, number 1 for 7C and number 2 for not considering that the matter have gone to court and damages were reduced to 20%. Okay, so that means whatever is due also that is wiped out. Then there's no question of escape amounts. I mean, exam being being recoverable at this stage. And number 2 is that they'll have to compute the entire fresh assessment for the only date payments for a certain period minus the period that's already been assessed. You take instructions. Yes.
Regarding that period also, my lord, there is a.
No, you'll have submissions.
No, my lord, it says damages. There is no limitation, perhaps, regarding this.
Maybe we'll set the damages at 5%, considering the conduct of this PF commissioner.
Lordship, we have.
If we have to disregard, he has disregard for court orders. He doesn't even take consideration. It's come to the court that damages are reduced. Even then, they seek to restart a matter, to re-agitate, to revive a matter 2004 in 2022. In spite of the express provisions of the Act that beyond 5 years should not be done.
Lordship,
Yes.
we have in my affidavit, Lordship.
You go prepare yourself. You take the instructions.
In fact, this is the reason I have made Union of India Ministry of Labour Party, my lord. My
I think it should have been
will not
struck
strike
off.
out. They should know.
They
They should know what they are doing here. These people, they are not even properly trained, my lord. Very unfortunate.
Call an officer, will tell him. He's still here.
Yes.
Manipur, I think.
He is now presently he is in Manipur. Yes.
Then he should be sent for training, I think. If he's responsible officer sitting in that chair and he sees something comes out of the machine that there's some escape amount, he mechanically draws up proceedings for that period.
Lordship, we have he has taken into consideration, Lordship, and
The court of the court.
Lordship, here in the order, Lordship, it was reflected that he has in the contention made by the.
No contention has reflected that in spite of the findings of the court, which we accept, and where payment has been made 25% of damages, which has been received by the Provident Fund Commission, we feel that for these reasons, in spite of 7C, that we reopen this matter for those assessment years. Is that permissible?
Lordship, the escape amount under section
Don't
7(c).
escape amount. Next matter. Enough. You
Second
take
clause.
instructions.
Item 12.
You convey to them the quote. It says, yes.
Item 12.
What you say, Mr. Sen, is absurd. Really. Spinning. Where are the other parties? Yes. Number 1, number 2. Yes. What do you want to say?
I'm in item 12, my lord.
Yes.
The petitioner has sought time condonation of delay in
Yes.
filing the election, my lord. Kindly see section 81, my lord. Section 81 of the People's Representative Act, my lord. Representation of People's Act. And section 81, my lord.
Yes.
An election petition calling in question any election may be presented on one or more of the grounds as specified in subsection 1 of section 100 and section 101 up to the High Court by any candidate at such election or any elector. My lord, kindly mark these words, may be presented by any candidate at any such election or elector. So the requirement in 181 is that it has to be by candidate, presentation has to be by candidate or elector. Even lawyer cannot file the petition, my lord, that Supreme Court has said, and on this ground alone, the petition has to be dismissed. Now, within 45 days, my lord, I will place that judgment, within 45 days from not earlier than the date of election of return candidate. So it has to be within 45 days, my lord. First, it has to be ground question to the Honorable High Court. Then, my lord, it has to be presented by candidate. Third, my lord, it has to be within 40, but not earlier than date of election of return candidate. Or if there are more than one return candidate at the election, dates of their elections are different, and those of the later of those two dates, my lord. Now, my lord, kindly see 81(3). Every election petition shall be accompanied by as many copies thereof as their respondents mention in the petition, and every such copy shall be attested by petitioner under his own signature to be a true copy of the petition. This has also not been complied, my lord. 81(3), 81 and 81(3) has not been complied.
Election petition has to be, see, it has to be presented by the person concerned itself before the High Court registry.
Yes, sir.
That is a mandate of the law.
Yeah, that is the mandate of your lordship is absolutely right. Now, your lordship will kindly see 3, my lord. 3 it also says that as many copies thereof as the respondent mentioned in the petition.
Yeah,
and every such
no, that is a given, Mr. Kumar. I mean, there has to be signed every page of petition that is served to the other side also. File has to be signed.
Not only signed, and that it has to be a signature to be a true copy of the petition. My lord, kindly see 82 also. A petitioner shall join as a respondent to his petition. So who will be the parties to election petition, my lord? 82. A petitioner shall join as a respondent to his petition, where the petitioner, in addition to claiming declaration that the election of all or any of written candidate is void, claim a further declaration that he himself or any other candidate has been duly elected, all the contesting candidates other than petitioner, and where no such further declaration is claimed, all the return candidates. So only return candidates can be joined as party under 82, my lord. That is 83, my lord, is content. An election petition shall contain a concise statement of material facts on full particulars, my lord, and C, my lord, 83 1C shall be signed by petitioner and verified in the manner laid down in the Code of Seal Procedure for the verification of pleading. And my lord, kindly see proviso also, provided that where petitioner alleges any corrupt practice, the petitioner shall also be accompanied by an affidavit in the prescribed form in support of the allegation of such corrupt practice and particulars thereof. 2. Any schedule or annexure to the petition shall also be signed by the petitioner and verified in the same manner in the petition. Now, my lord, kindly see 86. What 86, my lord? Section 86 of the Representation of People Act. The High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or Section 82 or Section 170. So, if 81 is not followed, my lord, 81 has got 45 days, my lord, true copy, signed and verification, my lord, which I have pointed out. The High Court shall dismiss an election petition which does not comply with the provisions of 81, 82 or Section 87. My lord, kindly see one procedural aspect in Section 87 and then I will take your lordship 87, my lord. Subject to provisions of this Act, 87, your lordship has saying, subject to the provisions of this Act and any of the rules made thereunder, every election petition shall be tried by the High Court as nearly as may be in accordance with procedure applicable.
That's what the court said earlier. At least the court should be aware that like a trial was sued.
Yes, my lord. Now, kindly see first part. Subject to the provisions of this Act and of any rules made thereunder, my lord. Now, your lordship has made the rules for conducting the election petition, my lord, because those rules of Guwahati High Court have been adopted by your lordship. Kindly see my affidavit in this regard, my lord. First, my lord, kindly see one judgment.
I think she's not ready. Where's your leading counsel?
Your Honor, he is from Guwahati, so he could not come today.
Doesn't matter.
Because I have only placed the judgment, my lord.
He was 2?
Nothing else.
1 week time, Lordship.
No, he was 2. What are you saying just now?
He is not present today, Lordship.
My lord, I have placed
you see,
the
you have
judgment
to
only.
impress upon the council that, election is hyper-technical also. You see, the thing is
It's
that
very
how,
technical, my lord.
that
No
is why
judgment
this
if I
court
get-
is very concerned about how even the election petition is drafted, how it's signed, how it's sworn. Every line should be, the affidavit to